So, hello everyone, and welcome, and appreciate you tuning in to listen to our conversation today with Craig Leen, who I'll introduce in just a moment. Today's conversation is going to be around employment and people with disabilities in today's kind of political and economic environment. And specifically, I came up with a title, we'll just call it Legal Considerations for Companies Supporting Employees and Prospective Employees with Disabilities in Today's Environment. And we'll also kind of take the nuanced view of what does it mean for people who are neurodivergent as a subset. So my name is Ron Sokolov, and I work with BroadFutures, a national nonprofit whose mission is to celebrate neurodiversity by creating access, cultivating skills, and revolutionizing the workplace for all. So more tactically, what that means is we partner with organizations, corporations, nonprofits, government agencies to create pathways to employment, both directly and indirectly, for young neurodivergent people through these organizations' internship programs. And through that model, we have supported over 500 young people in over a decade with over 80 partners. And for those who participate in our national program, which is with Fortune 1000 companies, over 75% of our interns have been offered full-time roles upon graduation. So for the talent acquisition folks in the room, that means a conversion rate. And in the past couple of months, I've talked with probably about 50 Fortune 1000 companies and around potentially partnering with BroadFutures, just understanding, what they're doing around neurodiversity. And the conversations have reflected, I would say, a mix of resolve, apprehension, hesitation, and uncertainty around investing right now in initiatives to support people with disabilities and including neuroinclusion. I think that hesitation, it's fair to say, has less to do with the lack of desire or cost, because those really are not, thankfully, obstacles typically, but more so to do with fearing the unknown and risk that in light of what is the self-described anti-DEI agenda of the Trump administration. And so that gets to the crux of today's conversation that we'll talk with Craig about, is to understand, do programs that support, corporate programs support people with disabilities and attract people with disabilities in their workforce, present legal and other risks for companies today. So, as I said, joining me today to help us peel back the onion is Craig Leen, one of the nation's experts on disability employment laws. Welcome, Craig.
Thank you. It's great to be here, Ron. Good to talk to you today.
Awesome. So Craig is a partner at K&L Gates in the firm's labor, employment, and workplace safety practice, and he co-leads the firm's Office of Federal Contract Compliance Programs and Affirmative Action Compliance area. His firm is one of the big ones with over 2,000 attorneys. Craig's experience spans across the federal, state, and local government, as well as the private sector. Prior to joining his current firm, he served as director of the Office of Federal Contract Compliance at the Department of Labor and an attorney at municipal and county level in Florida. Craig, we are very lucky and grateful to have him today. He's frequently consulted by organizations on disability inclusion, including neurodiversity and accessibility programs, and speaks around the country at a number of forums. So, and lots of rewards and accolades, but we'll skip those in the interest of time. That Craig, just know that we're lucky to have him. So, Craig, if I missed anything you think it's relevant to share about you and your background.
I mean, I do a lot of focus on disability. I also focus more generally on civil rights compliance. Um, I help companies address sort of these DEI executive orders we're going to talk about today, how to comply with them, how to approach them. And I am a disability advocate, and I'm a parent of a daughter who's profoundly autistic with an intellectual disability, Alexandra. She's 20, and so it's something very important to me. So I'm happy to be here and hoping all that are listening are hope that I can help them and give them peace of mind that they should continue these disability inclusion efforts and neurodiversity in the workplace efforts, things like that.
Yeah, wonderful. And thank you for sharing the personal aspect. I think with a lot of folks, I know with a lot of folks who are involved in this space, whether in the legal angle or not, have a personal story like that with a child or a sibling. So, um,
I
so
do, and I self-identify myself with disability, and I should note I served in the first Trump administration when I was when I was the director of OFCCP, it was under President Trump,
Okay.
and he nominated me to be OPM, Office of Personnel Management Inspector General. And that was toward the end of the administration, so they never got to me in the Senate. As far as I
Mm.
know, there was no objection, but they never got to me. So I didn't get confirmed at that point. So I just finished my time as OCCP director, and I've been in the private sector since that, except that I do serve as vice chair of the DC Advisory Committee to the U.S. Commission on Civil Rights. So I do a little bit of government work there, and then I'm the co-chair of the DC Family Support Council, which is a DC council, DC governing body that represents individuals with intellectual and developmental disability. That's the constituency to the Department of for Disability Services in DC. So I've stayed a little bit involved in government, but I'm mostly in the private sector. But a lot of companies come to me because I did serve in the first Trump administration. I do represent companies before the Trump administration. I know many people in the Trump administration. I talk to them a lot. So I have some insights into where they're going that I think could be helpful.
No, that's great. It's funny. I knew a lot of people in the first Trump administration, but not many of them survived to the second Trump administration. So it's if those people continue, that's you've got a small subset of that population. Um, so let's start with a review of what's happened in the last few months. I know there's been at least a couple executive orders, a number of injunctions and temporary restraining or not restraining orders, TROs, what do you call it, at the district court level.
Restraining orders.
Yeah, restraining orders, right?
That's
Okay,
right.
I was a wannabe attorney. Took the LSAT, but didn't take the next step. Staged at the circuit court, and then OPM, as you said, the Office of Personnel Management, has offered a number of clarifying memos. And so I'm going to give you I'm just going to set this up, but really quickly turn it to you. And I think, for the private sector, perhaps the most relevant of the executive orders is EO 14173, which is titled Ending Illegal Discrimination, Restoring Merit-Based Opportunity. And what this does in a nutshell is revoke, among other things, Executive Order 11246, which dates back to 1965, and the Johnson administration have been continually re-upped by presidents since. And following the revocation of the 11246, there's a lot of concern among communities, particularly those within the disability community, that programs to support people with disabilities would become illegal or perhaps targets of the administration. And so companies began to have a lot of the hesitation, I think, that I was talking about. OPM issued a clarification memo a couple of weeks later saying it was a carve out for people with disabilities. So that's kind of like the big picture. But I think what if you could help us kind of break down and walk through for our listeners what are the key, if I including more detail on those, and any key aspects that I've missed, and kind of where do things stand today? Like how did I look with all the legal,
So I
move?
think you're right. I think you're right to identify EO 14173 as sort of the main executive order in this area right now. It's the one that so there was another executive order that addressed the federal workforce. This addresses EO 14173 addresses the private sector much more. So that's why it's of more interest to most companies, nonprofits, organizations, because they want to make sure that they're in compliance, and they also want to know what does that mean, compliance in this particular context. So that's the first thing. 14173 is more focused on the private sector, but it is divided up into different parts of the private sector. So the first part of 14173 is focused on federal contractors and federal fund recipients. So entities that are doing business with the government or receiving grant dollars from the government in order to do research or produce something. And also, to some extent, government subcontractors. So companies that are contracting with government contractors to do work for the federal government. And the federal government does billions, hundreds of billions of dollars in federal contracts a year, but it may even be in the trillions now. But that could be anywhere from building a military jet to providing iPhones to government employees or, some sort of technology or computer. It can telecommunication services, food services, at the government cafeteria, government vehicles. It can be anything that, the US government is huge, multi-trillion dollar entity. And so it does a lot of corporate business. So about a quarter of the American population or the American workforce works for a federal contractor. And when you include the subcontractors, those doing work for a contractor, um, those building a part that goes into a smartphone or that goes into a jet, it's probably getting close to over half or maybe even more. So the federal government is by far the most influential employer. And a lot of times when influential business or organization, it's not a business, but when it acts like a business, it's one of the most influential. It is the most influential, I would say, in the world. So typically, when they enter into a contract or they give grants, there's a lot of red tape. There's a lot of, we're trying to reduce the red tape a little bit, but there's a lot of conditions, requirements that you sign on to. You take a dollar from the government, you agree to a host of things. For a long time, that was Executive Order 11246, the President Johnson executive order you mentioned. And you agreed to do affirmative action and non-discrimination and put together programs and be audited as a federal contractor. There are other obligations as well. There's a lot of them. So, you agree to that by being a federal contractor. So the first thing that this executive order does, 14173, it eliminates 11246. So those obligations now are gone for federal contractors. The duty to do affirmative action for women and minorities, that's gone. Now, a couple parts of affirmative action were kept, and that's Section 503 of the Rehabilitation Act and VEVRA, that's disability and veterans. And we'll get to that in a little bit. So that was kept, and it's good for people with disabilities that 503 and VEVRA were kept. So you got that, but 11246 was eliminated. Then 11246 was essentially was replaced with a couple other obligations. So, and these obligations only apply to contractors and grant recipients. And those are the two new federal acquisition regulation clauses. So now if you're going to be a federal contractor or a grant recipient, this applies to grant recipients too, even if you're not a contractor. So, a lot of universities are grant recipients, a lot of research organizations are grant recipients. So you are a lot of groups that help build the workforce, like through WIOA, for example, workforce opportunity. That's through grants as well. So you receive this grant money, you're agreeing to two new clauses. One, which says that you are in compliance with federal anti-discrimination law, which good, you would hope they would be. And that's something that a Democratic administration might keep as well. I mean, that's good. That's part of the federal government's job, is to make sure you're following federal anti-discrimination law. That includes the ADA and Section 503, by the way. And then there's the second clause, which is the more controversial one, which says that you agree that you certify that you do not have a DEI program that violates federal anti-discrimination law. So this quarter, or maybe even more when you include grant recipients, this huge part of the American economy now, so many businesses are being confronted with these two clauses, and they're having to certify that they do not have a DEI program that violates federal anti-discrimination law. So that's the second part, and we'll get to that a little bit more too. That's the second part. And then the third part of this Executive Order 14173 is trying to convince, I think it even says something to that effect in there, encourage and convince the private sector, even non-contractors, to eliminate their DEI program. And so they make their case that DEI is, I guess, anti-merit. This is not coming from me. This is their position. Because it's focused on in their view, non-job related factors, and that in the United States, there should be no favoring anyone based on race or gender. So that's basically that position. And then they say that they empower the Attorney General of the United States and every agency head to look at their agreements and there's another executive order that addresses this too. But one, they're supposed to cancel any DEI agreements that they have, the federal agencies. Two, if they're working with companies, they should be encouraging them to move away from DEI. And three, just even within their regulatory power, they're supposed to look for companies that practice DEI in a way that's illegal and target them for investigations. So there's a whole portion of the executive order focused on investigations, trying to encourage the private workforce generally and private employers from moving away from DEI. So that in a nutshell is the DEI, anti-DEI executive order 14173. You asked me what is its current status. So it's being enforced. There have been several lawsuits, you're right, that have been filed. There's been a couple injunctions issued and at least one injunction lifted. So I'll go through those very quickly. There are three main cases that I think really impact this area. Let me pull them up. The first is in the first one, temporarily, is from the District of Maryland, National Association of Diversity Officers in Higher Education v. Trump. Pretty soon after this executive order was issued, this lawsuit was filed. I think some public entities are involved with this too, and they filed this lawsuit in the District of Maryland, and pretty quickly, a federal district judge enjoined or blocked parts of Executive Order 14173, particularly the certification requirements I was talking about. They allowed DOJ to continue investigating anti-DEI, but everything else was sort of blocked. So,
But just to clarify, that's also just at the district level, then that's not necessarily.
that's it, but it was a nationwide injunction, so it blocked everything nationally. Now, that was one of the first court decisions that was issued where you saw the Trump administration really push back hard and say, we don't agree with this. Why do district judges get to issue these nationwide injunctions? We're unhappy about this. They appealed this order very quickly. And the Fourth Circuit Court of Appeal, which is the appeal that oversees the District of Maryland, they lifted the order. So they're basically finding that the Trump administration can continue to enforce 14173 during the course of that lawsuit. So that also usually is an indication that they're probably going to uphold it in some way. So because they're letting it be enforced. So that's the first case. The second case was District of DC, National Urban League v. Trump. In that case, a district judge in DC denied a preliminary injunction. And there's, at least as far as I know, there's no appeal pending right now. So that case, there's no injunction. And it's been denied. So at least in the District of Maryland and District of DC, that issue's been decided for right now, and there's no injunction. The one case where there is an injunction is the Eastern District of Illinois, Chicago Women in Trades v. Trump. There was a preliminary injunction issued applying only to the Labor Department that prevents labor from enforcing the certification requirement or canceling equity-related contracts. It's a limited preliminary injunction, though. It only applies to DOL. And, I think that the administration may even take the view that it really only applies to Chicago Women in Trades because they take very narrow views of this. But DOL doesn't do a lot of federal contracting. It does issue a fair amount of grants, though. So there is some impact here, but the thing is that most federal contractors and grant recipients don't only do business with one department. So if they do business with any other department, they're subject to the certification and the other requirement, and those can still be enforced because of the limitations of this order. So that's the current status of the cases. So right now, for the most part, Executive Order 14173 is enforceable. It's being enforced outside of the Department of Labor. And it's something that you need to be careful about because the reason I say that is because typically when you're a federal grant recipient or a contractor, it's hard to debar you or hard to take away your contract. It goes through a long process. When I was a CCP director, we could debar a company for discriminating, but we would typically have to go through a full administrative law judge process, Administrative Procedure Act. It goes through to the Administrative Review Board. It goes up to the court system. And at any time, if the company that we were enforcing against agreed to comply, then we can't debar them. I mean, that's essentially what happened. So companies never got involuntarily debarred because they would just come into compliance. They would contest the matter, and then if they lose, they would just come into compliance. That is not how it's working now. So the executive branch is not giving companies the ability to go to a judge to try to block them from, they're not making a finding and giving you a chance to challenge it before you lose your contract. They're just canceling contract. And when they do it, they're doing it for convenience. So they're even saying, look, we're not trying to penalize you. You do DEI, we're anti-DEI. This is not the interest of the government to do business with you. So, we're canceling the contract, but we're going to pay you up until the date that we cancel, but you're just going to lose it going forward, and you're going to lose your grant going forward. So that's sort of the position they're taking, which of course, for a company that's dependent on these contracts or grants, or even if they're not, even if it's just a significant part of the business, that could be devastating. So, that's not, but that's why you're seeing a lot of companies, what you told me before, a lot of entities are putting their heads down. They're trying not to get in the way of the Trump administration. They're trying not to become a focus. They don't want to lose their contracts. They know that they may have a First Amendment right to have a DEI program, but they're worried that they're still gonna lose their contracts. And a lot of companies are being pragmatic and trying to keep them. And then of course, some companies did have DEI programs that had preferences or quotas, and they're using this opportunity to correct that. So, because that is illegal. That was illegal under the Biden administration too. You can't have preferences or quotas. So now, having said all of that, and I've said a lot, I would just say one other thing. None of this touches on disability inclusion programs. Now, if you call that a DEI program, it might get sort of swept up in it a little bit because they are focused on DEI programs, but you are allowed to have a disability inclusion program.
Yeah,
And
we'll get to that. We'll get to that in just a second, kind of what that, well, I won't call it a carve out, but why? Because it's not a carve out, as much as it's just not, right?
they don't view that as an illegal DEI.
Exactly. So just to recap one thing, I mean, what you're saying is where, I will go with your estimate of close to half the business or half the money that I've spent of our economy touches the federal government, or is a customer of the federal government directly or down the supply chain, second, third tier chain supplier. And then just for, folks to think about, this could mean even if the company's buying stuff like iPhones, right? Because that could then be Apple, or it could be if they're buying office supplies, which that could be Walmart, Target, Office Depot, or you name the organization. There's a huge portion of the economy and a lot of names that you think of in every day that we as consumers buy as well, that also serve the government and are potentially at risk here. The one thing you talked about that I want to just, if you can shed a little light on, is you said that they have to affirmatively state essentially that they don't have a DEI. And DEI can be somewhat of an ambiguous. It could be like a philosophy, or it could be actually very specific concrete actions that someone takes to with either in the workforce for promotions or what have you. So what does it mean for a company or an entity to affirmatively state, I don't have any DEI?
So, that's a good question. And I should note, because I mentioned it before, just so the amount of federal contract dollars is about 760 billion each
Okay.
year, and the amount of grants is well over $1 trillion. So we're talking about a lot
Yeah.
of money. So it's very possible that you are going to be asked this question. Even if you don't think you're a federal contractor or grant recipient, you might be a subcontractor or subrecipient. So you might get the question from another entity that's trying to comply with the Trump administration's order, and they've been asked to ask all their subcontractors this question. So, and you may see this question coming up more and more because companies don't want to run afoul of the Trump administration position. So, you'll be asked this question, what does it mean? Well, one, you should note that illegal DEI itself has not been defined in the executive order. So in many ways, DEI is more of an enforcement priority. What they're saying is that if you operate a DEI program, we're going to look at it. And if it violates federal anti-discrimination law, we're going to enforce against you. So a lot of it is the name DEI. That term, it engenders a lot of different views and thoughts depending on what side of the political spectrum you're on. Many DEI programs are beloved, by companies, particularly on the left, more progressive companies or leaders in companies, feeling that it was necessary to address historic inequities, a lack of generational wealth among minority communities, making the playing field fairer. So there is a lot of love for DEI programs on the left, and I think there's been a real hit to morale. On the right, I believe DEI programs have largely been viewed negatively as being sort of a proxy for a preference or a quota that excludes men and excludes white workers and sometimes Asian workers too. And that for white workers, it also excludes any notion of class or socioeconomic class. So if if you grew up in an underprivileged area of the country and didn't have a lot of funds and maybe were the first person to go to college, but you're white, you might not be included in the DEI program. Whereas if you're black and you did have a lot of economic advantage, you would be included. And so there was a degree of, I think, resentment from the right and some of the constituencies that make up President Trump's base that DEI didn't include them, that it excluded them. Age was another area that wasn't included in most DEI programs. Disability sometimes was not included in DEI programs, about 95% of the time, actually. So it was rarely included. Religion was not included, so it was race and gender, and sometimes LGBTQ plus status. But the other components, veterans were often not included in DEI programs. So there is a degree of controversy around DEI based on where you sit on the political spectrum and where you think more resources need to be provided. So, the reason I give that background is in defining DEI, it helps to know that sort of background, how the right views it, how the left views it. So when I'm looking at what is illegal DEI, I'm thinking a little bit, well, are groups excluded from the DEI program? So if your DEI program provides employment benefits, so maybe you get to participate in employee resource groups, maybe you even get paid extra if you participate in the employee resource group, maybe you get access to mentorship programs or pipeline programs or executive training programs that will help you to advance, in part to address glass ceilings that often impact women and minorities. But if you have that sort of program and it's not open to everyone, even if white employees are less likely to use those programs or men are less likely to sign up for that pipeline program or glass ceiling program, if you exclude those groups, that is what they view, in my view, as illegal DEI. That's a DEI program that's exclusive, that it does not include other groups. And then if your DEI program conveys the idea that race, and this comes right from the EOC, from acting chair Lucas, who basically wrote this and said this several times that I've seen. If race, but she even issued a memo with the Department of Justice that says this: if race or gender is a motivating factor in your employment decisions, or if your DEI program conveys to people, you know what, you're white, you're male, you're not going to have as good a chance to advance because we're really focused on advancing women and minorities to executive level positions, and that message is conveyed, you're subject to risk. That there is a possibility that might create a hostile work environment, or that might create an environment where someone feels like race or sex is a motivating factor in an employment decision to their detriment. And one other thing happened, and it wasn't from President Trump, it was from the Supreme Court. And I'm not talking about the affirmative action decision. That obviously was a big one that many people know about. I'm talking about a little bit lesser known decision. It's called Muldrow, the Muldrow decision. But that was a decision about a year ago where the Supreme Court found that under Title VII, it used to be that you had to impact someone pretty significantly. You had to harm them. They had to be denied a raise, or they had to be denied a promotion, or they had to be fired for that to be an adverse employment action that would constitute discrimination. Now the Supreme Court has said any differential treatment could be discrimination. So it used to be that having a mentorship program that was only open to women probably was not violating Muldrow. It wasn't a significant enough negative to those who couldn't participate, but now it probably is. So that's why, the Supreme Court comes into play here too. So anyway, so it's a long answer, and
Yeah.
companies want short feedback. The short feedback would be any program that has a preference or an exclusion would be illegal. So if you have a preference based on race or gender, or you're excluding people from a program based on race or gender, whether you call it DEI or not, but they're going to be more focused on it if it's called DEI, because they're going to assume that it might include a program like this. That is what's illegal. Preferences, exclusions. That's the way I would think of it.
Okay, and then you focus on race and gender a lot, and then you also, from the Monroe decision, it was the definition of harm, I think, or what is constituted as harm has now been broadened. It's like even like
it's been broadened a lot.
Right. Okay. So let's then pivot a bit here now and talk about, because you said with Section 503 of the Rehabilitation Act, right, is not part of this, and I think OPM in its memo explicitly affirmatively stated that, because there was a lot of uncertainty at that point. So we've discussed in general what the executive order does, who could be subject to it, what those consequences are, and how to kind of evaluate whether you might be subject to legal action by the administration. But disabilities are not, and I want to dive into. I want to first just talk about like what does it mean. So like if someone has a program, let's just just make it a bit more concrete for folks here. If someone has a program that says we are specifically going out and looking for people with disabilities because we believe that it's important, then how is that implicated, if at all, by this executive order, or is that something that is okay to do or not okay to do today?
In my view, that's generally okay to do. And in fact, something you should be doing, because the labor force it's a tight labor market, and people with disabilities are underutilized, under-tapped part of the labor force. So you absolutely should be doing specific outreach, targeted outreach to people with disabilities. The reason why it doesn't cause a problem with Title VII or the ADA in this case, or similar to how race and gender do cause, if you targeted hiring toward women or toward minorities, that would cause a problem, because that would be a motivating factor, race or gender. The reason it goes a little bit to what a protected class is. So when I say that race is a protected class, that means that you can't discriminate based on race. So that includes white workers. You can't discriminate against a worker because they're white or black or Hispanic or Asian or Native American or Pacific Islander or multiracial. You can't do that. And white is as included as the other categories. Same with sex. You can't discriminate against women. You can't discriminate against men based on their sex. That is not true and that's true for other categories too. Like it's true for LGBTQ+. You can't discriminate against someone because they are transgender or cisgender, because they're gay or straight. You can't. Even if discrimination is more likely to be against someone because they're gay than because they're straight, historically, you still can't you can't discriminate against someone because they're straight. So those protected classes apply to the entire category. Disability and veteran status is different. If you are disabled, you're protected. If you're not disabled, you receive no protection from the law. So you're not considered a protected class. Same with veterans. If you're not a veteran, you don't receive a protection. But if you are a veteran, you do. So that is why there's a difference. I mean, that is the legal reason why the two are very different. I'd also say more in terms of public policy, maybe in terms of the perspective of the Trump administration. With people with disabilities, I think the idea is that the ADA and Section 503, they build in the idea that people with disabilities are different sometimes. They have a disability that makes it harder for them sometimes to be in the workforce without an accommodation. So there's a reason, there's a job-related reason why they should be treated differently, which is that this person could add a lot to this workforce. They could do an outstanding job with or without a disability, but because of their disability, there's a roadblock, there's an obstacle, but this accommodation will take care of it, and then they'll be able to fully participate. So, and that should be easy to do, and it should be common, it should be done as a matter of course, and companies should work that into their business model so that they're providing these sort of accommodations as a matter of course. So I think the administration would tell you, and this is one area where Democratic and Republican administrations tend to agree, perhaps for different reasons to some extent. I think Democratic administrations take more of the social model of disability, wanting to bring people with disabilities into all aspects of life, and employment. I think on the Republican side, there's still a little bit more of maybe the charitable or medical model of disability, although some of the social model, but the idea, okay, you're facing an obstacle. It's up to government. It's okay for government to come in here and to help you. You've seen this in the Medicaid debate. For people who are not disabled, and I understand this is a complicated discussion, but at least with what you're hearing from the Republican administration, well, if you're not disabled and you don't have dependents, you need to work. But if you are disabled, then of course, then you don't need to work, because that's why Medicaid's there, to help people who may not be able to work. So the point is, now, of course, missing here is that a lot of people with disabilities can work and want to work. And so I think they're largely talking about people with the most significant disabilities, like my daughter, for example, where it's much more of a challenge to be in the workforce, but they need that Medicaid. They depend on the Medicaid.
Right.
So
I mean, when you talk about, I mean, folks, let's zoom in on neurodivergence, because a lot of people who are neurodivergent are, it's approximately 20% of the population, and I mean, there are CEOs. Some people say Elon Musk, but I'm not, saying this.
well, Elon Musk has said that he
About
said that
himself, as he said about himself. Okay, so, but the point is, there are doctors, or lawyers, or engineers, or teachers. There's many people are neurodivergent, and there's many neurodivergence is a broad term and can mean a lot. There are a number of people who are neurodivergent, probably with some small levels of support, particularly, let's say, around executive functioning, can be will be and are hugely productive and important pieces of the workforce. The challenge some face is getting into the workforce. For a number of reasons, I think, both on the hiring side as well as their own, some of the around the executive functioning challenges that exist for some. And I don't mean to generalize here about, what any challenge anyone has. So you spoke a lot about it's okay and it's different with a protected class as disabled. But we spoke more kind of the anecdotes and examples you're giving, people who are already employed, for those in accommodations and such. For those who are non-employed and are trying to get into the workforce and face those barriers, obstacles to get in, what would you advise companies who are saying, anywhere from, we are specifically looking for people who have some form of disability to bring them into the workforce, or let's say, even look at the case where saying, hey, we have a goal of 5%. I'm just making up a number here, but of the folks that we bring in this next year's class of first year, employees, we'll say associates at a law firm, only because that's your world. But just like I say, we want 5% to be people with disabled, not ironclad, doesn't have to be, but that's a goal. Is that kosher? Is that okay in light of and including, just think of the overall, like, is that going to raise eyebrows now, just given the kind of political climate that we have now, and given the executive order, even if it's not necessarily specifically addressed by it?
So a few things to address. First, you can definitely set goals. In fact, if you're a federal contractor, you still have the 7% utilization rate goal, which is required by law, which you should be setting if you're a federal contractor. Um, the federal government also sets goals under Section 501 of the Rehabilitation Act. They set goals for people with disabilities generally and for people with targeted disabilities, which are very significant disabilities often. So, the federal government does that. Companies can do that. Uh, that's not viewed as discrimination because you're seeking to, it's traditional affirmative action in that you're going to an underutilized part of the labor market, people with disabilities, but it's also not violating anti-discrimination law because, as mentioned before, having a disability is the protected class, not having a disability. So it's true. There's probably a lot of we're finding. So you mentioned Elon Musk, and just to be specific, Elon Musk, when he was on SNL, said that he had Asperger's syndrome, which is, under it's no longer it's not in the DSM-5, but in the DSM-4, that was part of the. It's now been folded up together under autism spectrum disorder, so it's on the spectrum. But it used to be the part of the spectrum where you sometimes had the really, really brilliant people who were very good in tech, and that was, Asperger's syndrome, and it was part of the spectrum. So, and he's identified that way. What I would note, though, is that there are, and in fact, I visited a lot of autism at work programs, which had people who had been diagnosed with Asperger's or now ASD, but were on that part of the spectrum and were brilliant. Had some work challenges sometimes, and that depends on how much, the spectrum, every person's unique. But the point is that what autism advocates were trying to do, though, was because a lot of those individuals who were speculated to have Asperger's or who had Asperger's were, they did extremely well in the workplace. But the point was that there were other people who were not tech savants or brilliant at tech, who were regular at tech and did a bunch of other things, and we wanted them included too, and we didn't want that stereotype to exist for the whole spectrum. So, and I think that that's largely, I think that was part of the reason why in the DSM-5 they moved to ASD, and they have the broader spectrum. There's challenges with the broader spectrum too, challenges for people like my daughter, because I have to really explain more now when I say she has autism. Yes, she has, I sometimes say profound autism. I think I could say autism level, ASD level 3, or that she needs substantial supports, but I need to explain that more now than I did before. Because I do want to make sure that if she's going into a program, that they know that they need to be ready for her and she needs a one-on-one, and she's mostly nonverbal, so but it's a very broad spectrum. So now getting to the specific point of setting goals, before we get to the goals, I think every company should have a disability inclusion program. And I think that you should include even non-contractors. Contractors, you're supposed to. Federal contractors under 503, both as a question of law, like as a compliance requirement, and also as a best practice, you should have disability inclusion embedded in what you're doing as an organization. You should have a centralized accommodation system. You should be seeking to meet the 7% utilization goal. That including neurodiversity, because what we found is that neurodiversity is a very big umbrella and includes a lot of the neurodivergent related disabilities, include autism, as many people know, but it also includes ADHD, PTSD. It can include anxiety and depression. It can include learning disabilities, dyslexia, dyspraxia. So a variety of different, and when you actually really drill down, at some point in our lives, most people, I'd say a majority of people, have had a condition that could be considered to be under the neurodiversity umbrella. When you use it, and certainly under the mental health umbrella, and under and the broadest one is the non-apparent disability umbrella. That really is the key to meeting the 7% goal. I saw a study among lawyers once that said that if you include anxiety, depression, ADHD, and a couple other issues, that it could be 60%. I mean, it was a real study that said 60%. So, and now the reason I make that point is it may not be 60%. It might be 20% or 25 or 30. But the point is it's well above 7. So probably you're already meeting the 7% goal, but people don't either, they're either afraid to say they have a disability. They don't want to tell you that because they think you're going to judge them and or maybe discriminate against them or not give them as good a work or not advance them. So they have that worry, or they might not view themselves as having a disability. And in part, that may be because you haven't really done a training program which would tell that individual, hey, you know what? I've never thought of myself as disabled, but I do have this mental health condition. I could, if I can make a few adjustments to my workplace, or I'm neurodivergent, I could, if I made a few adjustments to my workplace, I would do better. I could seek that as an accommodation and they'll give it to me. Like, oh, well, that's going to increase my productivity. So there is an interest in people self-identifying as having a disability if they're in a workplace that values that and that's going to help them get whatever supports they need.
I mean, so it sounds like, would it be fair to say that for a company, even if they're a direct contractor with the government right now, they should not, now there's, political risk and there's all the other types of risk, but from a legal risk standpoint, right? Speaking from that standpoint, if they came out and said, we have this great disability support program, both for existing employees and resource groups, ERGs and BRGs, which a lot have, there's been a lot of, cancellation of those at places or pauses on those. But if they have one specifically for disabilities, and they want to bring in more people and are going and working with other organizations, third parties that help them bring in people with disabilities into the workforce, they should have no hesitation from a legal standpoint, is what you're counseling here, right? To go out and say, we're doing this and we fully support it and
I
stand.
mean, you should, if you're going to do a big program that's going to bring a lot of attention, you should get legal advice. I mean, I'm giving you some general principles, but you should actually have an attorney look at it. They're going to tell you sometimes there's attorneys are a little risk averse in these areas, so you should get someone who really knows the area and can advise you on what you can do. Because I remember when I was OCCP director, a lot of times it was the general counsel's office that would block some of these disability initiatives to the point that we had to start putting out, and some of the guidance is still there, but a lot of it's been taken down. But putting out guidance saying, no, you absolutely can favor disability in employment. This is legal. That's the view of the EOC, of the Office of Disability Employment Policy, of OFCCP. You are allowed to favor disability employment. And, and explaining the underlying rationale was because ultimately it's good for you as an employer, it's good for the people with disabilities, and you're not discriminating against anyone. So it doesn't cause harm. It increases opportunity to a part of the workforce that's heavily underutilized. It's the lowest labor force participation rate of any group
Yeah.
in the American economy is people with disabilities. So there's a real business reason to do this sort of outreach. So that's the so I'd say that, but then I'd also say I think that yeah, from a practical standpoint, I don't think the administration is going to be concerned if you're doing disability hiring. Now, if you call it DEI, this is our DEI program, and your DEIA program, you add the A, and then you're including disability within your DEI program, and then you're also doing it for race and gender or for other groups, it may all get swept up together, and they may, but if you're rolling out a disability inclusion program, and that's what you call it, and it's focused on giving people with disabilities an opportunity to work for you, and it depends on what type of program it is. If it's people with very significant disabilities, there may be a lot of supports, like an autism in the workplace program for people on all parts of the spectrum. That may, for some people, require a fair amount of support. Whereas if it's more, we're recruiting people with disabilities, we want people with disabilities, we have an easy way to, it's easy to get accommodations, we value that population. That's not controversial at all. And that's something you definitely should do. And the autism hiring programs you should do too. You just need to make it clear when you're doing them that they're voluntary.
Yep.
And that there's still another path for anyone who wants to just apply traditionally to your company. And assuming you do those two things, you're generally going to be in a good spot. The only other area where there's risk is just making sure that you're preserving confidentiality where the person wants that. So,
Mhm.
you're not supposed to, like autism at work programs, they'll sometimes train if they bring someone who's fairly impacted by autism in the workplace, they might train the people around them that are going to be their colleagues as to how to interact with someone with autism and what autism is. But you can only do that if the person gives you consent and says you can tell them that I have autism and train them. If the person says, I don't want anyone to know I have autism, I just want this accommodation, then you have to respect that. The ADA requires you to treat that information confidentially.
Yeah. So I mean, it sounds like, just if we're talking from a very practical standpoint, someone, let's say in talent acquisitions, the head of talent acquisitions, um, wants to start a program to hire people with disabilities. The kind of the do's and the don'ts of, I'm going to try to recap here and see if there's anything to add or guidance you would provide. Not, one, seek legal counsel, number one, just to review it, their own counsel. But some practical tips would be, don't include it within a DEI or DEIA umbrella. You're just shedding unnecessary attention and risk on it. B, make sure there are other pathways for people, for who don't have disabilities to get into the workforce. And there was one other thing I was going to say that I think you had mentioned that was that I thought was helpful.
Would add some, if you're a federal contractor, I would do it as part of your Section 503 program. I would do it as part of that. That's going to give you the most legal cover. And when you go to your counsel, it's important how you go to counsel. If you go to counsel and say, I'm really scared about 14173, I want to eliminate all risk, should we do this at all? Most counsel are going to tell you, oh, well, then eliminate these programs. I mean, attorneys are generally risk averse. What you have to do is go to the counsel and say, it's worth it to us to, we're seeking to comply in all these areas, but it's worth it to us to have a disability hiring program, a disability inclusion program. How can we mitigate the risk, or eliminate it? And, what are your thoughts on this? And it's our understanding that we can do this because disability is not being disabled is not a protected class. And if you give them that sort of background, they'll help you put together a program that will have minimal risk. And in fact, my experience, and I was a general counsel for a city for a time, is that disability inclusion programs decrease legal risk significantly. They one of the most likely area for you to get a discrimination claim is in the ADA. Every year the EOC publishes their complaints, and the number one complaint is retaliation, and the number two complaint is ADA, disability discrimination. Every year, it's the most likely and most risky in some ways, because a lot of times, in my experience, I have seen that a lot of the race-based and gender-based ones, a lot of it depends on the perspective of the person. The supervisor has one view, the employee has another view. A lot of times the EOC is just going to issue a right to sue, and they're not going to pursue it because they're going to say, well, now that we saw what the employer's perspective was, we're not going to go so far to say this was discrimination, but you have a right to try to prove it. And many of those claims get dismissed or summary judgment when they go to trial. The disability claims are more likely to be successful because a lot of times companies are denying an accommodation when they shouldn't. And they're going to say, I can't tell you how many people I've heard say, oh, well, that's not fair. That's special treatment. And no, that's equal treatment. You needed to give them that accommodation, or you denied them this or that. And you do see that is a risky claim. So if you have that's a risk. Disability is an area where there is risk if you don't have these sort of compliance programs. So if you have a disability inclusion program and you're granting accommodations as a matter of course, and you're training people on neurodiversity and on appropriate etiquette and how to talk to people and how to interact with people, and on how to grant accommodations, and that the company wants them to grant accommodations of their supervisors, and even creating that centralized system, the amount of risk that you've reduced, the chance that you're going to have a non-disabled person come and make a claim, which the EOC would throw out because there's no protected class, or a court would throw out, the chances of that are almost zero. The chances that the administration, which has been pro-disability, I understand that there's debate on that, but at least if you ask them, they believe they have because of that OPM memo and some of the other initiatives they did in the first administration. To do something to help workers with disabilities, I have not seen, it's now been almost 120 days. I have not seen them do one thing against an employer because of that. That has not been the focus of their anti-DEI efforts. It's all been in the race and gender area.
Yeah.
and
No,
to
it's
some
interesting.
extent in the gender identity area, but
So it's
it has
essentially
not been in the disability area.
disability. So intentionally having a disability, whether hiring or accommodation, et cetera, type program is a risk mitigation.
Absolutely.
You're saying, like, to actually decrease your legal
Yeah.
exposure.
And if you get a claim, a disability related claim, you're going to bring that up in your response. No, no, wait. We as an organization care deeply about including people with disabilities, about accessibility. We have this great program. We did
Yeah,
all of this. The person followed the program. We didn't discriminate here, and you'll have that defense.
yeah,
It's the chances of it being used against you. All I can tell you is I've not seen one instance of that, and I work in this field.
yeah. That's wonderful. Wonderful. Well, I mean, I think this has been very helpful. I mean, hopefully what I'm hoping is that companies take away from this is, I mean, in short, that they should not fear um, having programs to accommodate people with disabilities, to bring people with disabilities into the workforce, that this is not either a part of the executive order, B, is actually protected under the law, and C, has not generated any attention or any legal action by the administration whatsoever. In the last, since in 120 days or so that we've had this administration. So those are all, I think, positive and reinforcements to, hey, perhaps this is an opportunity to focus on this particular area of the workforce, which for me has not gotten the attention that it needs. We've talked about the high levels, very briefly, of
Absolutely.
disability and unemployment. Now's a chance to actually do something to put resources here and make a difference without having concern and helping your company's top line, bottom line, and society kind of being a good corporate citizen.
Absolutely. Accessibility initiatives tend to help all employees too. And there's a lot of studies out there that say that if you have a disability inclusive workplace, it's a more productive, happier one. Because a lot of, making it easier to get workplace supports, accommodations, having centralized systems, that helps everybody. Universal design, that idea that you can, get a chair that's, ergonomic chair if you need one, or a standing desk, and that it's done as a matter of course. That's very, all of those things are great for morale. Having a employee resource group for people with disabilities and for caregivers of people with disabilities can be life-saving sometimes. Even like I work a lot in the IEP area too. I help my daughter as an IEP in an individualized education program. I I work with people. You can have a caregivers group that can talk, oh, my child who has a disability, they need this IEP. Do you have any thoughts? Do you have any thoughts? But anyway, it's nice to have groups like that to support each other. So if anything, I agree with what you just said, Ron. I would double down on disability. It's a good opportunity to do so. And then, when everything comes back around and the Democrats come back one day as the Democratic administration, you're not going to get in any trouble for having done that. Like that's something that it tends to be bipartisan. So I would do it.
Awesome. Awesome. Well, Craig, thank you so much for your time today. I'm hoping, as I said, that this has been, for everyone listening who will be listening, very informative, and addresses some of the concerns that folks may have about if and whether and to proceed in intentionally supporting, I think is the important thing to say here, people with disabilities. So, Craig,
Absolutely.
thank you so much for your time, for your expertise.
My
Appreciate it.
pleasure.
All right,
Thanks,
wonderful.
Ian.
All right.
Well, thanks.